Greetings to all. Today I have been given the delicate task of discussing about fundamental right to freedom under Article 19(1)(a) to 19(1)(g), read with Article 19 Clause 2 to 19 Clause 3. Article 19 guarantees to the citizen of India 6 fundamental freedoms which are exercisable by them throughout the territory of India or any part of the territory of India. Those fundamental freedoms are freedom of speech and expression under Article 19(1)(a), freedom of assembly to assemble peaceably without arms, Article 19(1)(b), fundamental right to form associations or unions or cooperative society, Article 19(1)(c). Fourth fundamental freedom under Article 19(1) Clause D, right of the citizen to move freely throughout the territory of India. 19(1)(e), fundamental right to reside and settle in any part of the territory of India. And last fundamental freedom under Article 19(1) Clause G, right to practice any profession or carry on any occupation, trade or business. Fundamental rights guaranteed and enumerated under Article 19(1) are great and basic rights which are recognized as the natural rights inherent in the status of a citizen. Now, these fundamental freedoms given to the citizens are not absolute. Under Article 19(2) to 19(6), there are grounds on which reasonable restriction can be imposed. This is what the Supreme Court said in State of West Bengal versus Sumud Gopal, Bose, 1954 Supreme Court. None of the rights are absolute. Every fundamental freedom under 19(1)(a) to 19(1)(g) mentioned above, they are liable to be curtailed by the law made by the state or to be made by the state. But to the extent mentioned under Article 19 Clause 2 to 19 Clause 6. Now the difference in the content of the grounds under 19(2) Clause 2 to 19 Clause 6 indicate rights enumerated do not stand on a common pedestal, but they have varying dimensions and underlying philosophy. From the discussion, the following proposition logically emerges. First, restriction on the fundamental rights can only be imposed by law. You cannot impose restriction on the fundamental freedom through executive fiat or cabinet resolution. First proposition. Second proposition, restriction must be a reasonable restriction. Third proposition, restriction must be for the particular purpose mentioned in the relevant clause in relation to a particular fundamental freedom, which means 19(1)(a) must be read with 19 Clause 2. 19(1)(b) must be read with 19 Clause 3. 19 Clause 1c must be read with 19 Clause 4. 19 Clause 1d and e, it must be read with 19 Clause 5. And 19(1)(g) must be read with 19 Clause 6. First and the foremost point to be noted while dealing with fundamental freedom is Article 19, unlike Article 14, unlike Article 20, unlike Article 21 and 22 and Article 25 of the Constitution, Article 19 are available only to the citizens. Citizenship is a condition precedent for the availability of the fundamental freedom under Article 19(1)(a) to 19(1)(g). So an alien or a foreigner has no fundamental right under this article. Then the question comes whether a legal entity or a juristic person is entitled to fundamental freedom. Generally, juristic persons as registered company or a registered society are not treated as citizens. Only a natural person under the Constitution or law has the status of citizen can invoke fundamental freedom as mentioned by the Supreme Court in State Trading Corporation versus Commercial Tax Officer. But one important point that you always must remember is in Rustamji Kasauji Cooper versus Union of India, AIR 1970, and Bennett Coleman and Company versus Union of India 1973 Supreme Court. They have permitted the relief under Article 90 when the state action affects the right of an individual shareholder as well as the right of the company. Now, one important aspect when we deal with the anatomy of Article 19 is Constitution does not define the expression what is reasonable restriction. Now, kindly remember the reasonableness of restriction cannot be decided on an abstract standard or a general pattern of reasonableness which will be laid down for all cases, for all situations. The test may vary depending upon the facts and circumstances of each case. It may vary on the basis of time. It may vary on the basis of space. It may vary from case to case. In this lecture, a humble attempt is made to succinctly summarize the principles or parameters in ascertaining the reasonableness of restriction on the rights embodied in Article 19(1)(a) to 19(1)(g). Now, first and the foremost proposition which we can cull out from a catena of cases decided by the Supreme Court, first proposition is reasonableness instinctly invites proportionality. Chintaman Rao versus the State of MP, 1951 Supreme Court. Dwaraka Prasad versus State of UP in 1954 Supreme Court. In both the cases, Supreme Court categorically pointed out there must be a balance between the fundamental freedoms permitted under Article 19(1)(a) to 19(1)(g) and the social control permitted under Article 19(2) to 19(6). Unless and until the balance is ultimately reached, what happens is the restriction may ultimately be held not containing the quality of reasonableness. So therefore, 19(1)(a) to 19(1)(g), read with 19(2) to 6, it ultimately permits and permeates a balance between fundamental freedom and the social control permitted. And this is important because fundamental freedom under Article 19(1)(a) to 19(1)(g) are not absolute. This is one principle. The second proposition is Supreme Court would look into not only substantive restriction but also procedural restriction Virendra versus State of Punjab, 1957, you will find Supreme Court Journal, SEJ. Now, what is the meaning of the word substantive restriction and procedural restriction? Whenever a restriction is imposed by law, the duration and the content of restriction, it pertains to substantive part. And the court will go into whether the substantive provision is reasonable from the grounds stated under the relevant fundamental freedom. Now, say for example, there is a law which says a person will be imprisoned for 10 months and a person will be imprisoned for 2 years. Now, it is a substantive restriction because it deals with the duration of the restriction. From the point of view of this restriction, suppose say there is a law relating to externment, or for that matter there is a law relating to internment. Now that law may be challenged with reference to Article 19(1)(e), right to reside or settle in any part of the territory of India. Now the court will look into, having regard to the facts and circumstances of the case, whether this 10 months or otherwise, higher duration, whether it is substantively reasonable. Sometimes substantive law may be reasonable, but procedural restriction also will have to be gone into by a court of law. Now, procedural means what is the method and the manner in which restriction is imposed. Does the law involve notice, issuing of a notice? Does the law prescribe for reasonable opportunity of being heard? Does the law provide for review of the decision? Is there an appellate authority created under the statute? In respect of, you will find cases involving question of law, whether there is reference to the civil court. These are all matters relating to the procedural prerequisites. And if this procedure is absent, court may come to the conclusion that method and the manner in which this restriction is imposed is ultimately discriminatory, it is arbitrary, and therefore it is unreasonable, and court may strike down that particular law. In Virendra versus State of Punjab, there were two sections which came in for consideration. Section 2 of a particular enactment passed by the Punjab legislature. It provided that no news and views on certain matters affecting Hindi agitation should be published. But the duration of that particular prohibition was for not more than 2 months. And also it was pointed out, an appeal will lie from the decision given by the original authority. So the court pointed out the relevant section 2, it is constitutionally valid. But section 3 pointed out that the government can ban the entry and circulation of certain newspapers which were published outside the state of Punjab. Now, duration of the restriction was not mentioned. There was no mention also that appeal line. This is, you will find under the law. The decision of the authority was final. Now, court came to the conclusion that section 3 of the enactment passed by, you will find, the Punjab legislature. It is ultra-virus, Article 19(1)(a), namely freedom of press. Third important proposition which emerges, there must be a reasonable nexus between the restriction imposed and the object sought to be achieved by the act. So, this nexus must be established. Unless the nexus is established, court may come to the conclusion it is an unreasonable restriction. In Sudhi Shamshed Singh versus State of Persu, 1954 Supreme Court, and also famous Ram Manohar Lohiya's case. Court pointed out the restriction must have a reasonable nexus, intimate connection. You will find with the objects sought to be achieved by the act. In Shamsher Singh case, which I mentioned just now, a person circulated a pamphlet ridiculing and scandalizing the Chief Justice of Pepsu High Court. Consequent upon, he was sought to be detained under the law relating to preventive detention. He contended that there is no reasonable nexus between the restriction imposed and the object sought to be achieved by the act, because the Preventive Detention Act is passed with a view to maintain public order, security of the state, supplies essential to the community. Therefore, court said no nexus and he was released. Fourthly, reasonableness is an objective concept. It must be decided objectively. Now, court and the judges may have their own, you will find, personal predilection, personal views, and the values which they have imbibed may be different from the values which are generally available in the society. So, when we say that reasonableness is an objective concept, to my mind, we must not look it from the point of view of a citizen on whom restriction is imposed. We may have to see that objectivity from the point of view of in the interest of general public, which is mentioned as one of the grounds under Article 19(1) Clause D and E and Article 19 Clause 1 G, in the interest of general public. So when the legislature is passing the law, what are the objects with which legislature has passed that law? We will have to go into that. So that is why it is an objective concept. Look it from the point of view of felt needs of the society. Look it from the way why that particular law has been passed. What are the objectives for which that law has been enacted? Therefore, to my mind, one more thing that is to be added is, would a reasonable person consider it as unreasonable on the facts and circumstances of the case? Now, this factor, that is why it is an objective. That's why Justice Patanjali Shastri in State of Madras versus V.G. Rao, AAR 1952 Supreme Court, categorically came to the conclusion that when we interpret the concept of reasonableness, we must not be guided by our own philosophy. We must not be guided, but we must have a sobering reflection, a self-restraint and a sobering reflection that the Constitution is meant not only for us, it is also meant for everybody. Also, while deciding the reasonableness of restrictions, a judge may have his own values. Just see, Mr. Justice Patanjali Shastri categorically pointed out in State of Madras versus V.G. Rao, AAR 1952 Supreme Court, that the judges must be moved by the sense of responsibility, self-restraint, and sobering reflection that Constitution is meant not only for us, but for all. An elected representative, while making the law, has taken into account the needs of the felt society, and therefore the law was made. So therefore, it is, you will find, ultimately an objective concept, and that objective concept has to be viewed from multi-dimensional way, from the point of view of public, from the point of view of citizen, as well as the legislature, and the object that has been kept in mind by the legislature in making that particular law. This was approved by the Supreme Court in state of Gujarat versus Mirzapur, Modi, Qureshi, Kasab Jamal, 2005 Supreme Court cases. The next proposition is that reasonableness of restrictions only will have to be gone into and not the reasonableness of law. So a distinction was made between the reasonableness of law and the reasonableness of restriction. While applying this particular test, we will have to go into whether the legislature has put restrictions and whether the restrictions are going to affect the fundamental freedom. Then we have to look into what are the relevant grounds. So in N.B. Khare versus State of Delhi, 1950 Supreme Court said go into the restriction, not in the reasonableness of law. But after Maneka Gandhi versus Union of India and consequent adoption by the Supreme Court of composite code theory, making Article 14, Article 19 and Article 21 as a triangle, reasonableness of law can also be the legitimate focus for the interpretation by court. Because what is unreasonable under 21 can become unreasonable under Article 19. What is unreasonable under Article 19 and Article 21 can also become unreasonable by application of Article 14. Therefore, now there is a legitimate ground for the Supreme Court to look into the reasonableness of law because of integrated approach of Article 14, Article 19 and Article 31. Therefore, N.B. Khare versus State of Delhi to that extent must have been impliedly overruled after the landmark decision of the Supreme Court in Maneka Gandhi versus Union of India. Supreme Court also has further stated that reasonableness of restrictions in appropriate cases could also include prohibition. But when it ultimately reaches the stage of prohibition, there is a need for great, strict judicial review. In Narendra Kumar versus Union of India, AAR 1960 Supreme Court, non-ferrous metal order was issued by the Government of India under Section 3 of the Essential Commodities Act. And the effect and the impact of that particular non-ferrous metal order was to remove all the intermediary people between the manufacturer of the non-ferrous metal and the consumer of the non-ferrous metal. Government wanted a direct dealing between the manufacturer and the consumer so that the non-ferrous metal is available at reasonable price for satisfying the needs of the majority of the people in this particular country. So therefore, since intermediaries were ousted, Narendra Kumar challenged the constitutional validity of non-ferrous metal order as ultra-virus Article 19(1)(g) of the Constitution, and he pointed out it is not a restriction, it is a prohibition. I am ousted out from the trading aspect of non-ferrous metal, and therefore order should be struck down as ultra-virus 19(1)(g). Supreme Court, rejecting the contention, pointed out, as far as fundamental right to carry on any occupation, trade or business is concerned, the restrictions are greater. And especially after First Amendment to the Constitution of India, inserting, you will find, additional grounds, because originally under Article 19, Clause 6, only in the interest of general public was the ground on which restriction can be put. But later on, First Amendment to the Constitution categorically pointed out technical and professional qualification may be prescribed for carrying on trade, business, or practicing any profession. And the law may also create a monopoly in favor of the state or a corporation owned or controlled by the state after coming into First Amendment to the Constitution, insofar as it affected Article 19, Clause 6. So if a creation of a monopoly is permitted, automatically it will reach prohibition. And therefore, at least as far as the right under Article 19(1) is concerned, restriction includes prohibition. So this is another proposition which has been, you will find, mentioned and can be culled down from a catena of cases decided by the Supreme Court. Another proposition is, if a restriction is imposed with a view to implement the directive principles of state policy, it may be considered as a reasonable restriction. So therefore, whenever a law is passed and a restriction is put under that particular law, and if you can prove there is a reasonable, rational nexus between the law and the implementation of the directive principles of state policy, court will pursue it is reasonable. For example, you will find in a famous case, Muhammad Hanifa Qureshi versus State of BR, AIR, 1958 Supreme Court. The question that fell for consideration was whether banning slaughter, cow slaughter, whether it is ultra-virus, Article 19(1)(g), whether it is ultra-virus, Article 25, freedom of religion. That question came up for consideration. The argument on behalf of the state of BR was that banning cow slaughter is a directive principles of state policy. And therefore, you will find Supreme Court said it is a reasonable restriction, notwithstanding the fact it affects, you will find, ultimately, right to carry on trade. You will find extras. Now, in Kameshwar Singh versus State of BR, that famous case, you will find dealing with ultimately the Agricultural Reform, Land Reforms Act. It was argued that it is not for a public purpose within the meaning of Article 31, Clause 2, as it stood before 44 Constitutional Amendment. Supreme Court said, under Article 39, Clause B, resources of the community must be so distributed so as to subserve common good. And means of production should not be concentrated in few individuals, according to Article 39, Clause C. The Bihar Land Reforms Act ultimately is intended to give effect to this one, and therefore it is a public purpose, and therefore it is a reasonable restriction. You will find as far as Article 19(1)(f) was concerned, as it stood before 44 Constitutional Amendments. Another proposition which emerges from catena of cases decided by the Supreme Court is, if the statute confer administrative discretion, which is unguided, which is uncanalized, which is unbridled, it may impinge upon the relevant fundamental freedom, and the exercise of such conferment, such power may be declared as unreasonable. Now there are two cases or three cases which I might suggest here in order to explain this particular proposition with clarity in thinking and lucidity in explanation. Now the first case which I have to deal with under this particular proposition, you will find is what is known as Ibrahim Wazir versus State of Bombay, AAR, 1954 Supreme Court. In Ibrahim Wazir case, There was a law, influx from Pakistan Control Act, a pre-constitutional law. When there was a movement of the people from present Pakistan to India and from India to Pakistan, the law said a person cannot come to India without a permit. And if a person comes to India without a permit, he can be ultimately prosecuted. Action can be taken under the law, influx from Pakistan Control Act. And if a person comes without a valid permit, action can be taken. And power to determine under what circumstances action can be taken. The relevant operative provision of the Act pointed out, if the central government entertain a reasonable doubt an offence is committed, on such suspicion, person ultimately can be deported. So the contention before the Supreme Court was an unguided power has been given, uncanalized, unbridled power has been given, and this is left to the subjective satisfaction of the government, and the government is determining and taking ultimately action on ultimately subjective satisfaction, especially whether an offence has been committed or not. Therefore, argument that was advanced was, it is unguided, uncanalized power. It affects, and he is a citizen of India. Ibrahim Wazir was a citizen of India, and he has been asked to be deported. So therefore, Supreme Court said, such unguided, uncanalized power cannot be given. If it is given, it would amount to, or tantamount to, violation of Article 19, 1E of the Constitution, and action was struck down. There is what is known as Bharata Prasad versus State of UP, what is known as Coal Control Order case, under which authority was subject to subjective satisfaction, was given power ultimately to issue, to renew, to annul, to modify any license. On such ground, he or she may deem fit. Grounds have not been stated in the UP Coal Control Order. It was left to the subjective satisfaction of an authority. Grounds were given, grounds under what circumstances, subject to what conditions, this particular power could be exercised. It was not given, and therefore Supreme Court said such unguided, uncontrolled power amounts to violation of Article 19(1)(g), right to carry on occupation, trade and business, and Coal Control Order was struck down. Now there is a famous case, R.M. Seshadri versus District Magistrate Tanjavur, year 1954 Supreme Court, where notifications were issued by the District Magistrate under Cinematograph Act of 1952. And without obtaining license, a person cannot exhibit films. Now, under the direction which were issued by the competent authority under the Cinematograph Act, every exhibitor was required to show film of such length, and film of such, not only a film of such length, film for such duration, as may be specified by the authority from time to time. So therefore, the order did not specify, the notification did not specify what will be the duration of this documentary which is released by the Films Division. What should be the duration? That was not mentioned. And what should be the length of the film? Therefore, Supreme Court said it is not a reasonable restriction. It is an imposition. And that imposition affects the fundamental right of the petitioner. Now, when we deal with Article 19, I am reminded of a famous case, State of Madras versus V.G. Rao, to which I made reference earlier, 1952 Supreme Court. The question that fell for consideration was, in that particular case, People's Education Society, a society registered under the Madras Societies Registration Act, having library, doing other public activity. It was declared as an illegal association under the Madras Criminal Amendment Act, which was passed at that particular time, amended from time to time. So they challenged the constitutional validity. The question before the Supreme Court was how to determine reasonableness of restriction. What are the parameters? What are the principles which must be taken into account? Now, in that particular case, Supreme Court laid down 6 conditions, and Supreme Court categorically pointed out that reasonableness of restriction cannot be decided by an abstract standard. There cannot be a general formula which we can evolve. How to determine whether a particular restriction is a reasonable restriction for purposes of Article 19(1)(a) to 19(1)(g). In State of Madras versus V.G. Rao, Supreme Court laid down certain conditions because they said reasonableness of restriction cannot be decided by an abstract, you will find, consideration. A general formula cannot be evolved. It depends upon facts and circumstances of each case. And these 6 conditions, which I think Patanjali Shastri and his learned brothers, you will find, put it in State of Madras. First, nature of the right infringed. Whether it is freedom of speech and expression, whether it is freedom of business, whether it is freedom of association. What is the nature of the right infringed? It is one factor which the court has to take into account. Secondly, what are the underlying purposes for which restrictions have been imposed? So we are having a purposive. While the legislature is trying to impose restriction, what purposes prompted the legislature to put that particular restriction? Second. Third, what is the extent and the urgency of the evil sought to be remedied thereby? Why the legislature is putting a restriction? Was there any evil? Why that evil was sought to be removed? What is the urgency in removal or eradication of that evil? Court has to ultimately decide. Third. Fourth, disproportion of imposition. I pointed out to you proportionality, principle of proportionality. Fundamental freedom must be matched by the social control. And if this is a disproportion, ultimately, of imposition, as in R.M. Seshadri's case, there was a disproportion of imposition. And therefore, notification was held to be ultra vires the fundamental freedom. Then, what is the duration? What is the content of the restriction? Virendra versus, you will find, State of Punjab, this point was given. And lastly, prevailing conditions in the society at that particular time, when the action is initiated. Was the society peaceful? Whether there were, you will find, riots, whether there were breakdown of the law. So greater the absence of peace, greater the lack of public order, then greater the need ultimately to take urgent, immediate action. So all these must be entered into the judicial verdict. Therefore, if you look into the catena of cases decided by the Supreme Court, kindly note, the standard is elastic one. It varies with time, it varies with space and conditions, and from case to case, they have pointed out what is reasonable restriction. Now, 19(1)(a), especially freedom of speech and expression, which includes freedom of press, it is treated by the Supreme Court as mother of all fundamental freedoms under Article 19. And in fact, it constitutes the basic structure of the Constitution. Bennett, Gorman and Company versus Union of India, AIR 1986. Justice Pensey, as he then was, the single judge in that particular case, he pointed out that freedom of press, especially, is the basic structure of the Constitution. Now, in Bennett, Gorman and Company versus Union of India, the Bombay case, the question that fell for determination or that fell for consideration before the Bombay High Court was the constitutional validity of what is known as Monopoly and Restrictive Trade Practices Act. That law was inserted through a constitutional amendment in 9th schedule to the Constitution. Now, in 9th schedule to the Constitution, once the law is put into the 9th schedule, according to Article 31B of the Constitution, such a law shall not be void, or such a law shall not be deemed to have ever become void on the ground it is inconsistent with, or takes away, or abridges any one of the fundamental rights under Fundamental Rights Act. Now, in that particular case, Bennett, Gorman and Company entered into an undertaking with some other publisher of the newspaper, and according to the Union government, such an undertaking was in contravention of the operative provisions of Monopoly Restrictive Trade Practices Act. So, since it was in 9th schedule to the Constitution, the argument on behalf of the Union of India was the law, or for that matter, the action under the law, cannot be challenged on the ground. It is inconsistent with, or otherwise it takes away or abridges fundamental right, because 31B is a protective umbrella for the action or the purported action of the central government under the Monopoly Restrictive Trade Practices Act. But the argument of Bennett, Gorman and Company, because section, if I'm not mistaken, 21 and 22 of the Monopoly Restrictive Trade Practices Act, as amended from the Government of India from time to time, kindly known, if such an undertaking, if it is a dominant undertaking, now the Bennett, Gorman and Company may invite prosecution, criminal prosecution under the law. The petitioner, Bennett, Gorman and Company, contended that freedom of speech and expression, which is included under Article 19(1)(a), which includes freedom of press, it is a basic structure of the Constitution. Therefore, since it is a basic structure of the Constitution, the amendment by which Monopoly Restrictive Trade Practices Act has been put in, it is not applicable to the petitioner, namely newspaper industry. Because by invoking the doctrine of basic structure, you will find ultimately the Bombay High Court said that even though law is put in 9th schedule to the Constitution, it may come within the purview of protective umbrella under Article 31B, but a newspaper industry or management of the newspaper industry, ultimately the law will not apply, because freedom of speech and expression, which is ultimately includes freedom of press, is a basic structure of the Constitution. And therefore, ultimately, that amendment is applicable to non-newspaper industries and others, but it is not applicable ultimately to newspaper industry. Now, one important aspect which requires to be seen as far as Article 19 of the Constitution is concerned Earlier in A.K. Gopalan versus State of Madras, AAR 1915 Supreme Court, the question that fell for consideration was the relationship between Article 21 and 22 and Article 19 of the Constitution. Now in A.K. Gopalan's case, the first constitutional case, which was argued by Mr. M.K. Nambiar, his contention was that my client, A.K. Gopalan, is detained under the law relating to preventive detention. The law violates fundamental freedoms under Article 19.1a, 19.1b, 19.1c, 19.1d, 19.1e, and 19.1g. As a result of the detention, I am not able to exercise my fundamental freedom, and therefore, reasonableness of restriction should be looked into. Now, majority of the judges of the Supreme Court, you will find in that particular case, came to the conclusion that Article 21 and Article 22 is ultimately what is known as exclusive, mutually exclusive from Article 19 of the Constitution. If Article 21 and 22 are applicable, Article 19 cannot be applied. That was the interrelationship. In fact, Supreme Court in A.K. Gopalan came to this particular conclusion, invoked the doctrine of what is known as exclusivity of fundamental right on three grounds. First ground was 19 will be applicable only if the law directly abridges the fundamental freedom under Article 19.1d to 19.1g. Secondly, Article 21 and Article 22, they are self-contained code. Therefore, if you are detained, if you are arrested, if you are wrongfully confined, what we have to see is whether that law satisfies Articles 21 and 22 of the Constitution. Thirdly, fundamental freedoms can be invoked only by free person. You are not free, then fundamental freedoms cannot be invoked. That was the approach which was taken by the Supreme Court. But this approach was given a go by. You will find in one particular case, State of Maharashtra versus Prakhar Panduranga Sansgiri, AAR 1966 Supreme Court. Mr. Sansgiri was detained under the Defense of India rules. He was ultimately a teacher who was teaching science in, you will find, schools or educational institutions. When he was detained in the prison under the Defense of India rules, he sought permission from the state of Maharashtra to write the book on atom theory. Permission was granted by the state of Maharashtra. In pursuance of the permission, he started writing book. Manuscripts were ultimately ready. He wanted to publish, and he wanted permission from the Maharashtra government for publishing the book while he was undergoing detention. Permission was refused by the Maharashtra government. He went to the Supreme Court and asked for a writ of mandamus, compelling the state of Maharashtra to give permission to write the book. One of the arguments advanced on behalf of the state of Maharashtra was that if a person is detained under the preventive detention law, so long as he is a detainee, he cannot exercise the fundamental freedom of speech and expression, which includes freedom of press, and therefore publication of the book, permission need not be given. Supreme Court rejected the condition. Supreme Court said this interrelationship is, you will find one of the interpretation given by the earlier judges in A.K. Gopalan case. But the Supreme Court has not finally has taken What is that interrelationship? Therefore, Supreme Court went into the conditions under which the detainee was detained. Now, detainee was detained under the Bombay Preventive Conditions Order. Bombay Preventive Detention Conditions Order did not specify he cannot write the book or he cannot publish the book, etc., etc. Therefore, Supreme Court said, even though you are a detainee, you will find you can be subject only to authorized restriction, authorized by law. Law did not authorize such restriction, and therefore Article 21 of the Constitution is violated, which means detainee can exercise the fundamental freedom. So therefore, after Maneka Gandhi's case, you will find Article 21, Article 19, and Article 14 has become, you will find, a triangle. It has become a composite code theory. And what is unreasonable under 21 can legitimately be unreasonable under 19, both substantively or procedurally, as the case may be. And once both are there, Article 21 ultimately is also attractive. So therefore, the theory of exclusivity of fundamental rights, which was propounded by the Supreme Court in A.K. Gopalan versus State of Madras, it was actually, you will find, given a go by in bank nationalization case, R.C. Cooper versus Union of India, AR 1970. And later on, Maneka Gandhi explored the theory of exclusivity of fundamental rights. Now, Maneka Gandhi's case and subsequent cases decided by the Supreme Court, according to me, is correct because Article 13(2) categorically says, states shall not make any law which takes away or abridges the fundamental right. And when we say fundamental right, each and every fundamental right, it should not violate. We cannot adopt the theory of exclusivity of fundamental right, which goes against, you will find, fundamental freedom, which are considered as eternal, inviolable, sacred, and sacrosanct by the Supreme Court. Thank you very much.